Hello, my name is Nina Peckman, and I'm the staff attorney at the nonprofit organization Advocacy for Children of New Jersey. Today, I will be talking about the process of special education and how parents can be involved in decision-making. ACNJ's work over 40 years as an independent nonprofit organization has resulted in better laws and policies, more effective funding, and stronger services for children and families, giving more children a chance to grow up safe, healthy, and educated. We work closely with state and federal lawmakers and policymakers to bolster their understanding and response to the needs of children and families. The Kid Law Resource Center provides information and assistance to parents and those working with families about laws and legal processes affecting children, including education and child welfare issues. You can learn more about us at www.acnj.org. This presentation is intended for informational purposes only. It does not constitute legal advice. For assistance with a particular education issue, you can contact me, Nina Peckman, at ACNJ. This project is co-sponsored by the New Jersey State Bar Foundation and made possible through funding from the IOLTA Fund of the Bar of New Jersey. For additional information about the Foundation's other law-related activities, please call 1-800-FREE-LAW or visit the Foundation at njsbf.org. Special education is governed by the Individuals with Disabilities Act, the federal law. In addition, children who receive special education services, as well as children with disabilities who need supports and accommodations in school to have the same opportunities to learn as their non-disabled peers, are protected by the federal laws, Section 504 of the Rehabilitation Act and the American with Disabilities Act. Education rights and responsibilities are also established through New Jersey state laws. There is a link to these laws in the resource page of this presentation. Children from the date of their third birthday through age 21 may be eligible for special education if they have a disability that affects learning in school and requires special education services. The special education laws were created with the vision that the parents' role in education decisions was crucial to the education success of their children. These laws explain the parent participation rights. For education decision-making purposes, the following people can be considered a parent: a birth or adoptive parent, unless a court order says otherwise, a person acting like a parent, such as a legal guardian or relative, a resource parent, a surrogate parent who should be appointed if no parent is available, or the adult student. It's important to note that a state agency representative, such as a DCPMP caseworker, cannot sign parental consent. And also a non-custodial parent, meaning a parent who the child is not living with or is not living with most of the time, must be provided with notices, invited to meetings, and may make education decisions. It's also important to know who to address parent concerns to, so that the person with the authority to make decisions is made aware of any issues and appropriate responses are not delayed. In all cases, the first place to start is with the teacher. For special education issues, start with the case manager, and then if your concerns aren't addressed, you can go to a supervisor of special education or the director of student services. And if the school district can't address your concerns, you can address your concerns to a county supervisor of child study team located in the county superintendent's office. For discipline issues, you should start with the vice principal or principal. And then again, if your concerns aren't met, you can address your issues to the superintendent, and you can always appeal decisions to the Board of Education. And for harassment, intimidation, and bullying issues, or HIB, parents should contact the principal in writing for help and request a formal bullying investigation. Parents can also contact the district anti-bullying coordinator. For either discipline or HIB issues, parents should also contact the child study team to make them aware and to receive possible assistance. Effective communication with school staff is key to effective collaboration regarding a child. First, communicate concerns verbally. Then confirm conversations in writing to ensure that everyone is on the same page regarding next steps and what, if anything, was agreed to. Parents must submit formal written requests for evaluations, child study team, and IEP meetings to the case manager. They should date and sign all written communications and keep copies of all letters and notices to and from the school, previous evaluation reports, and IEPs. Finally, it's important to inform the child study team about medications, new issues at home, new diagnoses, and services that the student is receiving outside of school that may affect the student's ability to learn in school. Parents are entitled to school notices in a language they understand and to translation services. This is a sample letter requesting an IEP meeting that can be used for other kinds of requests, such as to request evaluations or to review the IEP. The IEP and other important special education meetings should be attended by relevant people to explore the issues and come up with an effective plan. Aside from the teachers, related service providers, and other school specialists that the child study team suggests, the parents should consider inviting a relevant specialist who evaluated or treated the student, a community provider such as a community-based therapist, and the student, if appropriate, to share their preferences. Parents can also invite an advocate or attorney to a meeting. Specialists and therapists tend to be busy, so letting the child study team know their availability in advance can help coordinate schedules. Parents can also suggest to the specialist that their participation can be limited to a portion of the meeting, or seeing if they are able to participate by phone or virtually instead of person, and to enable their participation. Anyone can refer a child for child study team evaluations. Refer means a written request for evaluations to the school's child study team or district's director of student services. This request may but does not have to include a relevant doctor's report or diagnosis. In addition, school districts have their own independent duty to identify children. Identify means to evaluate children in all areas of suspected disabilities. 20 calendar days from the time that the child study team receives a referral, the child study team must meet with the parent at a meeting known as the evaluation planning meeting to discuss potential evaluations. This meeting is attended by the child study team, parent, teachers, both a general education and special education teacher, and related service providers. There must be a teacher present with direct knowledge of the student. If the child study team and parent agree that evaluations are necessary, the parent will be provided with an evaluation plan to sign. After 90 calendar days from the date of the written consent, an eligibility meeting will be scheduled, and if the student is found to be eligible, an IEP development meeting will take place, usually immediately after on the same day. So what is the individualized education plan? It's a written agreement between the district and the parents regarding the education plan. And it's in effect for 1 year unless the parties agree in writing to an IEP amendment. The IEP contains a description of why the student needs special education services, objective data, including a summary of formal evaluation results that support the education plan, teacher observations, all the supports, accommodations, modifications, and special programs the student will need, all the related services the student will receive, such as speech and language therapy, occupational or physical therapy, social skills, reading, behavior assistance, recreation, executive functioning, social work and counseling services, medical or nursing services, or interpretive services for students with auditory impairments, to name a few. In addition, the IEP contains any special considerations, the need for transportation, an aid, health services, transition services, or the need for assistive technology. The IEP will also describe the placement and how progress will be measured through short-term and detailed objective goals. And finally, a statement of why the placement is the student's least restrictive environment. Within 20 calendar days of the referral, the child study team is responsible for conferring with the school nurse to obtain the student's current health information and consulting with the student's teachers regarding the child's academic progress. The child study team then observes the child in the classroom. The purpose of the evaluations is to fully understand the child's learning abilities, including any behavior issues in school, and to understand what kind of instruction, supports, accommodations, and setting a child needs. The team must propose a multidisciplinary evaluation consisting of at least 2 evaluations of the suspected disabilities, usually an education evaluation, a psychological evaluation, and a social evaluation. The education evaluation assesses what the student has learned, while the psychological evaluation primarily assesses the student's learning potential, but can also include a social emotional component if relevant. Together, these evaluations give a lot of information about how the child learns and their strengths and weaknesses. A social work assessment will also be conducted by asking the parents for information about relevant health and family history. Functional assessments should also be conducted. These are assessments that look at how the student performs in the classroom and school setting, both academically and behaviorally. Other evaluations should be conducted as necessary in order for the child study team to meet its obligation to fully identify all the areas of suspected disability and how they are impacting the student in school. The following are the most common additional evaluations, but other types of evaluations are possible if deemed appropriate. A speech and language evaluation for articulation or receptive, expressive, and pragmatic skills, physical therapy for gross motor issues, occupational for fine motor or sensory issues, reading for a suspected reading disability, assistive technology to determine the devices, equipment, and programs that a student might need to learn in school, a psychiatric assessment for a suspected emotional or behavior issue, or a neurological evaluation for a suspected neurological disorder that's affecting learning. At the evaluation planning meeting, parents can request other evaluations that the child study team did not suggest. Parents can also provide evaluation reports that they have paid for, which then must be considered in developing an IEP. For planning purposes, it is helpful to share these reports with the child study team prior to the meeting. Without parental written consent, evaluations cannot be conducted. However, because the child study team is obligated to evaluate students they suspect of being eligible for special education and/or related services, the district may file for due process to compel parents who may not believe their child requires services to consent to evaluations. Reports from the specialists who evaluated a child or from treating physicians can be very helpful in developing an appropriate plan. Some specialists are not accustomed to writing reports for school staff and may not realize what information school staff will find useful. Reports from qualified professionals should identify the assessments they conducted and observations that led to their conclusions and provide a clear statement of the diagnosis, how they believe the disability will affect the student in school, and specific recommendations. Sometimes it's also helpful for the evaluator and school staff to speak directly and share information. The parent would have to sign a release for this to happen. Also, it can be helpful for the private evaluators to read the current IEP and school evaluations prior to making recommendations. Keep in mind that the parent does not have to share private evaluation results and can exclude sensitive confidential information so that they feel comfortable while still providing helpful information from a report to school staff. The child study team should consider the parent's schedule when arranging for the eligibility and IEP meeting. If a parent's schedule or circumstances require it, they can participate via alternate means, such as by phone or virtually. It is a good idea for the parent to let the child study know in advance about particular requests and concerns. Another tip is to write questions and concerns down in advance so that the parent remembers to raise them during the meeting. Finally, parents must write to the child study team in advance if they wish to record the meeting, they need a translator, or if they are bringing a lawyer, advocate, or other professional. At least 10 days before the eligibility and IEP meetings, parents should receive copies of the child study team reports. The child study team will explain the evaluation results at the eligibility meeting and discuss evaluation reports that the parent provided. The child study team will then propose what they believe is the primary basis known as the classification for special education services, or explain why they believe the child is not eligible for special education. In either case, the child study team must provide the parent with an eligibility statement that explains the child study team's rationale for their decision. If a parent disagrees with how the evaluations were conducted, the validity of the reports and or the accuracy or thoroughness of the reports or the conclusions or recommendations, they may request additional child study team evaluations. They may also write to the child study team for one or more evaluations by specialists not employed by the district. This is known as a request for independent evaluations. If the child study team disagrees with the parent's request, the district must file for due process within 20 calendar days of the parent's written request, or they have to agree to the request. To obtain independent evaluations, the child study team and parent will agree on who will evaluate the child. The district must pay for these evaluations. When the child study team receives the request, if they agree, they must provide the parent with a list of potential evaluators, and the parent can also suggest evaluators. Agreements can include conditions such as the specific assessments that will be done, the qualifications of the evaluator, how the evaluation should be conducted, such as whether to include an observation, or the language it will be conducted in, or the setting for the evaluation. Child study team reevaluations must occur every 3 years. This is known as a triennial evaluation. These provide important, updated, objective information about how the child is progressing. Parents have the option to waive an evaluation, but do not have to agree to waive this right. Reevaluations should also occur prior to discontinuing services and can occur sooner, such as when new problems arise or due to appearance of insufficient progress. The IEP states the classification of the student, and the phrase that a child is classified for special education refers to these 14 categories that were established by the IDEA as disabilities that could make a child eligible for special education services. The eligibility is discussed and usually agreed to at the eligibility meeting, although it is possible to agree to change an eligibility category after the child has the IEP. IEPs can be for students who have behavior-based disabilities such as autism, ADHD, ODD, depression, or anxiety, to name a few, even if they have average or above average learning abilities, and even if they are an A student. While behavior strategies based on informal school assessments, observations, and plans may be sufficient for serious issues and that are not being helped through informal means, child study team evaluations, including a functional behavioral assessment, may be necessary to create an appropriate IEP. The IEP can include a behavior plan based upon a formal FBA that describes the behaviors that are the target of the plan, the triggers or the causes of the behaviors, and the specific strategies and positive supports that will be implemented to help the student. If counseling is provided, specific counseling and social emotional goals are appropriate. At the IEP development meeting, all participants will introduce themselves and will sign an attendance sheet. The child study team will discuss the proposed IEP following input by the teachers, therapists, parents, and other participants. Parents can ask questions as well as suggest and request services or a particular placement. The child study team will either present the parent with the proposed draft IEP at the meeting or will send the IEP to the parent following the meeting. Parents should carefully review the IEP draft, and if the parent has a serious concern, they can consider showing the draft to an advocate or a specialist working with the child before signing it. The parent can continue to make suggestions and changes to the draft IEP after the meeting and try to work out differences up until 15 calendar days following their receipt of the IEP, unless the child study team and parent agree to extend this period for additional discussions. Unless the 15-day period is extended, or if the parent files for mediation or due process, the IEP will become effective on the 15th calendar day after the parent receives the final draft IEP. Keep in mind that agreed parts of the IEP can be implemented even if Other evaluations are needed, which might lead to future IEP amendments, or even if the parent disputes some parts of the IEP. One of the IDEA requirements is that the student receive services in the least restrictive environment, and that the student have the opportunity to be with general education students to the extent possible. This least restrictive environment could be the general education class for students who can learn in that setting with reasonable accommodations or supports, a resource class for students who need a smaller setting or to be taught at a slower pace for one or more classes, or it could be a self-contained class for students who need more intensive services and more structure. Sometimes the least restrictive environment is an out-of-district placement when the school district cannot meet the student's needs, or a residential setting. Home instruction is considered the most restrictive setting and should be for a very limited period of time unless based upon a doctor's recommendation. Some people would say that the transition services are the most important part of a student's program, since these are the services that will prepare the student for life after high school. At age 14 or in 8th grade, the child study team will start planning, which can include instruction to help prepare the student to learn the transition skills needed for life after high school. An example of these services would be if the student expresses interest in a technology career, maybe in middle school, the IEP might include occupational therapy to address fine motor skills issues and keyboarding skills. If the child study team wishes to attend a competitive college, the child study team would ensure that the student is getting the curriculum necessary in middle school to prepare the student for the necessary high school classes. This planning process also includes yearly student interviews and skills assessments to determine interests, strengths, and weaknesses to help develop the individualized transition plan for the student. At age 16, the transition plan must be implemented. One option is for students to attend vocational school. The applications for these programs should be submitted in 8th grade, perhaps mid-year, but parents should check with the child study team for students who want a 4-year program. Students can also apply during high school, as there are 2-year and part-time programs. Transition services can include, among other services, specialized instruction, related services that will support the students' post-high school goals, community experiences, the development of post-school living and employment goals, and life skills and vocational evaluations. Regarding high school graduation requirements, students in special education have the right to statewide curriculum, including earning a minimum of 120 high school credits and to achieve high school credits through alternative means. They may also be excused from certain graduation requirements if their disability makes it impractical or impossible, and the child study team would have to agree. Students also have the right to achieve proficiency in PARCC assessments unless the IEP establishes alternative requirements. Students continuing beyond year 12 can walk at the graduation ceremony with their classmates and receive their diploma when they are ready to graduate. It's important to understand that the right to enrollment through age 21 depends upon achieving transition goals and not simply completing high school credit requirements. For students who turn 21 this or next school year, a new law related to the pandemic may make the student eligible for up to 1 additional year. Parents should discuss this option at an IEP meeting prior to June 2022 or June 2023, if applicable. When there are disagreements, there are several steps that a parent can take to try to resolve them with their district in a collaborative, informal way. The first step is to consider whether the parent and the school staff have all the relevant information to make decisions. Write to the child study team for copies of progress reports, including data and formal and informal assessment results. Write to the principal for behavior incident and school records if relevant. Consider asking a community provider who has worked with the student, or whether you have additional objective information that can help solve disagreements with the child study team. Speak to teachers and ask for an IEP meeting to try to resolve the issues. Parents can also talk to an advocate such as ACNJ or SPAN to understand applicable laws and strategies for resolving issues. Pro bono services are available. When issues can't be resolved, one option is to request mediation, which is done through the New Jersey Department of Education website or by mail. With mediation, a trained impartial mediator meets with the parent and school staff, usually at the Board of Education. The mediator cannot force an agreement. This process is completely voluntary. Nothing said in mediation sessions can be used against the other party in court. Both the parent and the school staff get an opportunity to state their concerns and wishes. The mediator can also take each party aside to speak with each privately so they can speak frankly about their wishes and offers of settlement. If an agreement is reached, the mediator writes it up, the parties sign it, and it is enforceable. If the mediation fails, it can be converted immediately to due process. Parents can file a complaint, known in education cases as a due process petition. These are decided by administrative law judges. Petitions are also filed electronically or mailed to the New Jersey Department of Education. A parent has an option to file for due process only or to file for due process and ask for a mediation first. When the parent files, the district can request a resolution session within 15 calendar days, which is like an IEP meeting to try to resolve the issues informally. The first notice from the Office of Administrative Law that a parent receives once the matter is referred to them will be to schedule a settlement conference before a judge who is only assigned to try to settle the case. If settlement cannot be reached, the case will be assigned to another judge for a hearing. When parents file for due process, a parent can request stay put, which means to request that a service or services or a placement in the current IEP remain in effect pending the outcome of the case. If parents do not want a service to stop or a placement to change, such as if the child's study team believes a student should be declassified or graduate or no longer needs a related services, then they must file for due process and request stay put within 15 calendar days of receiving a proposed IEP or before the proposed change goes into effect. Stay put occurs immediately upon the filing of the due process petition and stops an IEP from changing, pending an administrative law judge's decision or a resolution by the parties. Finally, it is very important to read and follow instructions carefully for filing both the due process and mediation to avoid the petition being returned and delaying this process. Here are helpful resources. And here are a select AC&J resources. Others can be found on our website. And now I thank you for attending. And again, you can contact me for information, Nina Peckman at AC&J. My email address is npeckman@acnj.org, and my phone number is 973-643-3876, extension 226.